All right, hey, this is Stephen A. Williams, president and founder of the creditrepairshop.com. In today's video, we're going to talk about Chase Bank, USANA Chase Bank Card Services for deceptive collection practices. And this was a consent order by the Consumer Financial Protection Bureau. Now, I was made aware of this by a YouTube subscriber, so I would like to thank him for making me aware of this. We all know that this was going on, but this gives me more foundational information to be able to help you fight back against credit card companies if they come after you in a way that violates your rights. Now, back during the financial crisis, way back in 2011, it said, the time just flies. There was an article that was recently posted that kind of reviewed what Chase had did back then. What they were doing is they were robo signing a whole bunch of lawsuits and going after people, and this is a violation according to the Consumer Financial Protection Bureau. Now, if you want to review that article, which I was made aware of by the YouTube subscriber, I cannot show the article here because when I do that, I seem to get these cease and desist from these companies, and I can understand because they don't want people just utilizing their content when they're trying to get paid for using it. But the article is a return to robo signing. JP Morgan Chase has unleashed a lawsuit blitz on credit card customers. This is a ProPublica article. Now, what I did is I went back to see the consent order by the Consumer Financial Protection Bureau. And so you can see here it says Consumer Financial Protection Bureau has reviewed the debt sale and collection practices of Chase Bank USA NA and its subsidiary Chase Bank Card Services, and has found that such practices violate Section 1036A1 and A3 of the Consumer Financial Protection Act. So now what is that right there? Because you're like, okay, Steve, what is that violation? So the violation is, it says Congress prohibits covered persons and services providers from committing or engaging in unfair, deceptive, or abusive acts or practices in connection with the offering or provisions of consumer financial products or services. So that's what that's about. So here's the overview. Respondents provided consumers with credit card accounts and also have acquired credit card accounts from other credit card users. At the end of 2012, now I know that's back in 2012, but they're doing this now because this consent order had expired, and now they have started ramping up doing the same thing all over again. So I'm telling you what you need to watch out for. At the end of 2012, respondents had approximately 64.5 million open accounts with 124 billion in outstanding credit card debt. When consumers failed to pay these accounts, they were placed in default. I'm going to use my little pencil here. They were placed in default. Right here, this is where we're at. Respondents collected on the defaulted debts through their internal collection attempts and during the time period relevant to this order by filing collection lawsuits. Respondents also collected on defaulted debts by selling defaulted accounts to third-party debt buyers who collected on those accounts, or by using all three methods from 2009 to 2012. Respondents recovered approximately 4.6 billion of the approximately 57 billion of debt from defaulted accounts using these methods. Now, I want to talk about this here before we move forward. Selling defaulted accounts to third-party debt buyers. Now, I've talked about that. When this will help you to get a charged off account either placed on your credit reports as paid for less or removed, because, and when they say respondents, they're saying the credit card company, when they sold that defaulted account to the third-party debt buyers who collected on those accounts by using all three methods from 2009 to 2012, and they are doing this now, so don't let this time frame fool you. But here's the golden nugget in this. When they buy those accounts, the original creditor is accepting payment on those accounts for less. So regardless if you paid them or the debt collector paid them, it must be placed on there that it was paid for less. And you might be saying, well, it's charged off. A charged off account, if you were to pay, let's just say, for instance, you were to go to your original creditor and say, hey, I cannot afford to pay this $5,000 credit card debt. And they say, okay, we will accept $2,500. Send that to us. We will say that it's accept that we're going to put it on your credit reports that it was paid for less. Did you know that right after they did that, the next month it would say charged off account? So there's really no difference. So if you pay it or a debt collector pays them the money, they've accepted it for less, and they do not put, follow me on this, they do not put how much it was paid for less. So if you paid half, they don't say, well, you paid half for less. Half of the debt. No, they just say it was settled for less. Listen to me. This is a way to get a charge off either removed or put on your credit reports paid for less. And the way that you do this, you don't do this only with the credit reporting agencies. You need to contact the credit card company and tell them to either put paid for less because they accepted payment for less, or they need to take it completely off of your credit reports because it is showing inaccurate. Now, respondents sold to debt buyers certain accounts that were inaccurate, settled, discharged in bankruptcy, not owed by the consumer, or otherwise uncollectible. It could be past statute of limitations. The debt buyers then sought to collect these inaccurate, settled, discharged, not owed, or otherwise uncollectible debts from consumers. Respondents filed lawsuits and obtained judgments against consumers using deceptive affidavits. I've talked about this, deceptive affidavits and other documents that were prepared without following required procedures because, for example, they were at times signing without, and let me move here so we can move the page up. Let's get my little pencil here so we can move the page up. Let's see, where were we at? It said here, let me find my spot. Respondents filed lawsuits and obtained judgments against consumers using deceptive affidavits and other documents that were prepared without following procedures because, for example, they were at times signing without personal knowledge of the signer, a practice commonly referred to as robo-signing. All right, let's go back here. Respondents made certain errors calculating pre and post judgment fees, interest when filing debt collection lawsuits, which resulted in judgments against consumers for incorrect amounts. Now, I've talked about this. Proving the claim. When a debt collector or the original creditor takes you to court, you have a right to make them calculate. I've talked about this so many times. You have a right to make them prove the entire claim. Look at this. They added in fees. They had the pre here is referring to the amount that they claim that you owe. And because no one really reviewed it, they're just throwing it up there. And because no one shows up to court, they just got default judgments. It didn't matter because no one was trying to fight them. So respondents practices harm consumers. Respondents subjected certain consumers to collection activities for accounts that were not theirs. For accounts that were not theirs. in amounts that were incorrect or uncollectible. That means that it was past the statute of limitations, or they had filed bankruptcy, or for other reasons that were really unknown to the consumer because no one was really checking this stuff out. Respondents also obtained judgments against consumers using documents that were falsely sworn. I talked about this here, falsely sworn. What is a falsely sworn document? Now, you will see that there's affidavits where they will try to make it look like the original creditor had sworn on an affidavit saying that the account was looked through. They'll say that I know the business records about from the original creditor. I know the process and all of this stuff. You will see that it'll say like an affidavit of account, and it will be signed by someone who works for the debt collector. But it tries to fool the court as if this is someone who works directly with the original creditor. So, and that at times contain inaccurate amounts because they don't know. They don't have real access to those documents. They just have a couple of statements and an amount and the last four digits of an account number. These actions may affect consumers' ability to obtain credit, employment, housing, and insurance in the future. This is why credit is so important. Because if you have information like this on your credit reports, even if it was something that you did do and it should remain on there, this is still a statement that you need to pay attention to on the reasons why it is important for you to work on your credit, is because these actions may affect consumers' ability if it's actions that were violations by the original creditor or debt collector, or if it's actions that are committed by you. It will harm your ability to obtain credit, employment, housing, and insurance. So this statement goes both ways. Respondents' practices misled consumers and courts and caused consumers to pay false or inaccurate debt and incur legal expenses and court fees to defend against valid or excessive claims. Respondents suspended collection litigation in 2011 and suspended all debt sales in December of 2013. Respondents state that they are not currently engaged in collection litigation or sale of debt with respect to their consumer credit card business, which is subject to this order. The Bureau brings this action to engage respondents do not revive these practices and obtain relief for injured consumers, and to impose or obtain civil money penalties. All right, let's move forward here. And then the Bureau has jurisdiction on this matter, and it talks about the section. So now let's get to the meat of this. The reason why this whole video was made is that they've started back doing this. On that ProPublica article, it had stated that Chase Bank, and from what I've seen, because I'm involved in this, other companies, other credit card companies have started doing this. The reasons why is because no one wants to show up in court for a variety of reasons. Either you might be afraid to show up in court because you don't know what to do, what to say. You know that the debt was yours, but you don't know your right on how you can challenge an original creditor or a debt collector. Now, I'm not talking about running from debt. What I'm talking about is that you're either going to put yourself in a situation to have a very good settlement, and there's nothing wrong with doing that. Companies do settlements with each other all the time. This is just like you treating your finances like a business. If you don't have the money to pay in full, you can always have the option to settle. But these companies are required to prove certain information when they're taking you to court. They cannot just be robo-signing and stating amounts that are not true and accurate. You have a right to challenge every penny that they claim that you owe. And when it's sent over to a debt collector to collect, that debt collector, regardless if they're collecting it for the original creditor or if they're collecting it for themselves, they have to prove every penny of that claim. And they also have to prove the the chain of custody on how they got the debt. And if they sold that debt to another debt collection company, maybe there's a portfolio company in the middle. You need to look at those documents because that could be a violation because of lawsuits like these. Certain credit card companies have made it against the rules for a portfolio company to sell the debt to another debt collection company because they don't want to have anyone that they don't have a direct relationship with going out there trying to collect debt that they had sold to another debt collector because that's what makes all of these types of problems come up. So if you are being sued by a debt collector, there is a link below my video. I would like to review your court summons because you may have a potential door open to either get your case dismissed or a very good settlement offer that you could put on the table to be able to resolve your situation so you will be able to move forward. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, go to the website, the3scores.com to grab your TransUnion, Equifax, and Experian credit reports and all 3 scores because you need that data to be able to know what you're going to be able to do with a debt collection from the original creditor. And if you're facing this situation, you're going to want that data because they could have submitted a 1099-C on your debt and you don't even know it. If you have debt collectors coming after you early in the game, grab my 3-pack of letters. Statute of limitations letter for debt that is past the legal statute of limitations. They talked about that in this lawsuit, in this stipulation. Also, if the debt is not past the legal statute of limitation or the time barred period of time, I give you a cease and desist collection activities letter, which will question debt collectors who buy your debt, and a debt validation letter so you can go back and forth with those debt collectors if they try to just send you a couple of statements. I do ask for a donation on those, but that is very little considering that those three letters can literally save you time, frustration, headaches, and your money. That donation helps me for my time that I put into making these videos for you. Thank you for your time. Please subscribe to the channel. Please like this video. Please share this video. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.